we'd like to go to our senior multimedia reporter, Bea Cupin, who is now live from the Senate. She is with the prosecution's legal spokesperson, Attorney Benjamin Tolosa. Bea?
Hi, John. I think you're going to take first crack at asking questions kay Attorney Tolosa.
Good afternoon.
Good afternoon. Thank you for making time for us. Maybe I'll start with the rulings at the tail end of the trial today. How do you feel about the motions being rejected, the one regarding the Las Cañas affidavit and the judicial notice being accepted by the impeachment court?
Yeah, we're very pleased with that because it will help expedite the proceedings. Because of that, one of our next intended witnesses won't have to identify and authenticate each of these records of the House of Representatives. So that will help move things along very quickly. So with respect to the qualification stated by the presiding officer that that the substance or the truth of the statements given by the witness during those hearings before the Congress will not be considered by the impeachment court to have been established already. That's okay with us because that's not really our intention when we filed that motion.
Attorney Tolosa, what about the skirmish in the afternoon regarding the acknowledgement receipts? No? How do you see? I mean, do you think that when you actually meet with the defense counsel with the second opportunity to do a sort of a pre-trial marking and so on and so forth, you'll be able to achieve some agreement, or you still expect them to not agree to stipulate any of the ARs?
Hopefully they'll be more cooperative and reasonable this time. As pointed out by Attorney Kapunan, we actually tried to do this during the pre-marking conference, as part of the pre-trial. But for some reason, they refused to even compare their documents with ours. So now, with respect to stipulations, as stated by the presiding officer, of course, we can't force them to enter into any stipulation. But at the very least, we should at least do the clerical act of comparing the exhibits marked by both parties so that we could already state before the clerk of court if we agree that these documents are similar to each other.
Thank you, Attorney. I'm done. No, I'd like to hand you back to Bea. She has a few more questions for you.
Sir, siguro to extend on your explanation, why is it so important? Kasi not a lot of the non-lawyers might be like, bakit importante to identify these documents in the first place?
Yes. So when we offer these documents in evidence, the rules require that we'll be able to properly identify them and authenticate them. So it means, it's to prove that these documents are authentic documents. So normally, to do it is you would have to put a witness on the stand, and then that witness will have to identify these documents and then authenticate them. So to authenticate them, if there are signatures, you have to identify those signatures and explain your basis as to why you're familiar with the signatures. But since these are common exhibits and these documents actually came from the Office of the Vice President and Department of Education, that's why we were asking them to just stipulate on these documents. So, these are, both of us will be using these documents, and again, it came from them. And as pointed out by Attorney Kapunan, in fact, there are so many signatures appearing on these documents, and those signatures were affixed by the concerned officers of DepEd and OVP. So we were hoping, again, so we wouldn't have to waste so much time during the trial itself, having to ask witnesses, authenticate these documents one by one. That's why we wanted to do that, on request for stipulation. But they did not agree, but at the very least, maybe this time we could just agree that these documents that we have, they're similar to each other by comparing them mechanically.
Sir, as in Wamil and with Del Ocampo right now, ang issue daw nila among maybe other things is the chain of custody. How do you make sense then of that? Is there room for agreement if that is their issue?
First of all, chain of custody. Are they questioning the COA? These are documents that have been submitted to the COA. No, are they saying that these documents were tampered by some COA official? So I don't know, but to be fair, let's hear their theory about this matter. But insofar as we're concerned, that's why even Attorney Kapunan even stated, let's expedite things. We can even just use your own evidence
Kayo
instead of ours.
mag-adjust.
Yes.
Sir, just taking a step back and making sense of the past 2.5 days of the trial, are we satisfied so far with with the facts and the narratives that we've surfaced through the redirect of Wamil before the impeachment court?
Yes, definitely. Even his responses to the clarificatory questions raised by the different senators today. We're very pleased with his answers. He was able to share very important details, yesterday and today. Among them is the fact that he was able to clearly explain what's the process that must be followed in using and liquidating confidential funds as stated in the Joint Circular 2015-01. And he also stated, he identified one by one what were the discrepancies, what were the issues that he found in the liquidation report submitted by the Office of the Vice President, the Department of Education. And, it's since he listed quite a lot of these issues and discrepancies, I would just like to perhaps highlight some of them.
Yes.
For example, he said, in his experience, this is the first time that an agency that is liquidating the use of confidential funds just was not able to submit not even one official receipt to prove the purchase of supplies, of medicine, whatever goods. Right? As he pointed out, everything that they submitted were just acknowledgement receipts. He also said that this is the first time that an agency approached them and requested, if possible, instead of issuing an AOM, if there are issues with their liquidation reports, just submit audit query. Right? He also stated that this is the first time they encountered wherein for payment of rewards, apparently the agency is claiming that they used medicine instead of cash. So, and I think another important thing that he did was he identified these different documents wherein it was shown that these liquidation reports and ultimately the use of that of that public funds were approved by the Vice President herself. And when asked repeatedly about this matter, he said that it's clear under the Joint Circular itself, if the accountable officer of that agency fails to liquidate despite demand, and he clarified that demands there means demand to liquidate, then that's a prima facie evidence of that accountable officer's use of those funds for his or her personal benefit. And as I've stated, it's clear the accountable officer in this case is the Vice President, being the head of the Office of the Vice President, the Department of Education.
Nabanggit ka ni Deputy Speaker Ortega kanina, concerned daw kayo kasi bakit kailangan ng medisina ng mga supposed recipients of confidential funds. But sir, touching on the press conference earlier this afternoon, you used the word unusual to describe the liquidation or lack thereof, allegedly of the OVP and the DepEd. Could you explain to us bakit of all the words that you could use in the English vocabulary, bakit unusual yung...
Because I just used the own words of the witness, Attorney Rodrigo Wamil. That's how he characterized them. He said it's unusual because, again, as stated, this is the first time that he experienced something like this. Payment of reward through medicine. Again, non-submission of even a single official receipt. Rather, what were submitted were just acknowledgement receipts. So
Sir, last na lang siguro for next week. Of course, we expect the supervising auditor to continue at the witness stand, but we also have plans to, or we are asking the court to subpoena Gina S. Acosta and Edward Fajarda, names that we've heard over and over again the past week or so. What do we expect? Do we expect to actually, for them to actually show up? And when and if they do, what do we expect from these two?
Well, they should show up if a subpoena are issued by the impeachment court directing them to appear as witnesses in this case. If they won't show up, then we'll avail of the remedies under the rules and the law, right? So to compel their attendance. As to what will be the subject of their testimony, of course, only in broad strokes, I could just say that, they are the special disbursing officers of the Office of the Vice President and Department of Education. So they were the ones who received the cash. So I'm sure there are very important information that they could share with us.
And maybe they can shed light on Mary Grace Piatos. Thank you for joining us, sir. We'll see you next week
Thank
again.
you as well for having me here.
John?
Thank you very much, Bea, and thank you, Attorney Tolosa.